Okay. I'm just chatting with some people in the chat box just to see how we're doing. If people don't have audio, someone mentioned that they don't have audio, but I'm not sure if that is if that's universal or if. Okay, awesome, good. It seems like that's not a problem anymore. So now I'm going to go and pull up my application again. In fact, actually, what I may do is, because there's a couple of things that I would like to show you on our website, I think instead of sharing the application, I'm going to share my desktop. So I'm going to start out by introducing myself. My name is Kristen O'Neill. I'm the Assistant Director of the New York State Committee on Open Government. And I have been with the committee for about 5.5 years now. I started in, I think, November of 2015. And prior to that, I was with Counsel's Office for the Office of Mental Health for 10 years. At the tail end of that, I served as the Record Access Officer for the Office of Mental Health. So my experience that brought me here was with the Freedom of Information Law and as a Record Access Officer for a state agency. And unlike a lot of people, I actually enjoyed the Freedom of Information Law, and I know it's the bane of a lot of people's existence, but I enjoy it, and so that's what brought me here to this office. For those of you that don't know a lot about what our office does, a little background is that we are a very tiny agency, that we are a staff of 3. We have our executive director, who's been with us for a bit over a year now. Her name is Shashan Boulay. We have our administrative assistant, Candace Watson-Cottle, and you have me, Kristen O'Neill. That is the entire staff of a very tiny state agency. We are administratively housed by the Department of State, but we are independent in terms of subject matter. So while they provide us administrative support, we have, they house us, they give us a place to stay and all sorts of technical and support from that nature. But from a subject matter standpoint, we are independent. And what we do on a day-to-day basis is provide advice, opinions, and training regarding the open government statutes, and that's the Freedom of Information Law, the Open Meetings Law, and the Personal Privacy Protection Law. Anyone is welcome to contact our office. We are open to the public. We are available for questions from the public, from the media, from government employees at the state and local level. Anyone with questions about open government statutes is welcome to contact us either in writing or by phone. The first thing I would like to do is I'm going to share my desktop, and let's hope I don't mess up too badly here. Let's see. I don't want to share my application. I want to share my desktop and escape out of the presentation for just a few minutes. And what I'd like to show you is the Committee on Open Government's homepage. This will be updated fairly soon. All the state agencies are trying to get up to speed in having an up-to-date, more user-friendly website. We want to keep all of the aspects of our website that people love and find useful, but also make it a little bit more user-friendly. It's a bit dated, but I just want to go over a few things so that people are aware of how to find information. This is our homepage. If you Google COOP, you'll find us. But another option is to go to the Department of State website, and from there are links to all the committees and commissions that are housed by the Department of State. You can find us there. From here, you'll see at the top of the screen there are several menu items, and what I want to show you particularly is here I have it's called I Would Like To. That's my I Would Like To menu. And I always get questions from everybody after the training, whether they can have access to the training materials. or whether maybe they missed a part of it, or they missed it entirely, or they want friends to view the program. Right here you'll see I have a link for view training recordings, and that brings you to Committee on Open Government's YouTube page. So here you will find previous training programs that I've done, and once we're done with this one, I will download it and then ask our IT folks to download this one as well. The other thing that people ask a lot about is the training material. So you'll see here the bottom option is view training materials. This is a copy of both the Freedom of Information Law and the Open Meetings Law training material. So it's got both sets of slides in one. So that's just the first thing I wanted to share with everybody before we got going. It's possible I might pop back to the website for other purposes, but for now we're going to go and start looking at our PowerPoint. And I'll put that in. There we go. So up on the screen you'll see is my contact information. There's the telephone number for our office. That's always the best number to try to reach anyone. As I mentioned, given the small size of our office, if you call that number, you'll probably either get myself or you'll get our administrative assistant, Candace. If we are telecommuting, you may need to leave a message and I'll get back to you, but I do try to return those phone calls as quickly as possible. There you'll see our website again, our web address, and my little thumbnail for Google to find us. The New York State Freedom of Information Law is codified in New York State Public Officers Law, Article 6, Sections 84 through 90. Here is a copy of a view of our website that I already showed you in person. In addition to the things that I already showed you, there is access to a lot of helpful information like copies of the statute, advisory opinions, case law summaries. So there's other information there as well that I can point you to. So going way back to the beginning of time, the original Freedom of Information Law was enacted in 1974. It was very limited in scope. It was the original version of the statute only gave access to 9 categories of records. So what it did was it said here's the type of records that you're permitted to access, and if you don't see it on this list, you're sort of out of luck. It's not going to be available to you. Nobody really loved that version of the statute, so in 1978, it was repealed and replaced with current versions. It's substantially the current version. Of course, there's been amendments to the statute over the years, but essentially it is the current version of the statute, which is based on a presumption of access. There we go. So, in the New York State Freedom of Information Law, there is a presumption of access to government records. You start with the assumption that all government records are subject to FOIL disclosure, and then the agency has an obligation to review those records to determine whether the records or portions of the records fit into one of the permissible grounds denial. So I very often get questions along the lines of, is this FOILable? And my response to that is generally everything is FOILable. You can ask for anything you want. Any government record that is maintained by a government agency, you can ask for it. There may be permissible reasons why the agency is not going to provide it to you, but that doesn't mean that you can't ask for it. So, you have this presumption of access. Another way this question is posed to me is sometimes I get the question, is this considered a public record? Well, it's a misleading question because, again, all records maintained by a government agency are subject to Freedom of Information Law. And there's no legal characterization of those records as either public or not public. It's, are they available under the Freedom of Information Law in whole or in part, or are they not? Those are the two questions that you ask, not so much are they public, capital P, records. Who is covered by the Freedom of Information Law? Freedom of Information Law gives access to agency records. And the term agency is defined as any state or municipal department, board, bureau, division, commission, committee, public authority, corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or any one or more municipalities thereof, except the judiciary or the state legislature. So of course that's a lot of information, a lot of words, but in essence, you know, at a very simple level, it's government agencies, it's towns, it's villages, it's counties and cities and school districts and fire districts and water districts and sewer districts and New York State agencies under the Executive Controller, under the Office of the State Comptroller, the Office of the Attorney General, all government agencies except for the judiciary. So the courts, access to court records is not governed by the Freedom of Information Law, governed by other statutes. And while access to state legislative records is governed by the Freedom of Information Law, they are not considered an agency as defined by the Freedom of Information Law. And that is because under FOIL, the state legislature's records, access to those records is completely different than access to all other government agency records. Access to state legislative records, actually, it harkens back to the original 1974 version of FOIL, where the law includes a list of the types of records you're permitted to obtain from the New York State Legislature, and if it's not on that list, you're sort of out of luck. Not to say that you can't ask for it, maybe they'll as a courtesy provide it to you, but from a statutory perspective, they would not be required to. So when I'm talking about agency records, I'm not talking about state legislative records, and I'm not talking about court records. And the term record again is defined very broadly under the Freedom of Information Law, and there is no legal distinction between, for example, the term public record is really never used in the Freedom of Information Law. The term record means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever, including but not limited to, and then you'll see a list of examples of the types of records, fairly self-explanatory. Any information in any physical form whatsoever. So it's very broad. Very briefly, I'm going to point out that there's a difference between the definition of record under the Freedom of Information Law and the definition of record established by the New York State Archives, for example. State government agencies, local government agencies are required to comply with record retention and disposition schedules established by the New York State Archives. What the New York State Archives considers a record is different from what we at the Committee on Open Government and what the Freedom of Information Law considers a record. Our definition is significantly broader. Essentially, the New York State Archives is focusing on records that an agency is required by law to maintain, and the Committee on Open Government, the Freedom of Information Law, is talking about any record maintained by an agency, whether they're required to maintain it or not. If I send an email to a friend who works at another government agency saying, hey, do you want to meet for lunch later, and we're both using our government-issued email accounts, that becomes a record subject to rights of access under FOIL. So that's how broad it is. Something as minor and as innocuous as that then becomes a record. Under the Freedom of Information Law, an agency is not required to create records. That is the general rule of thumb. You're not required to answer questions under the Freedom of Information Law. So, for example, if you're an applicant, if you're somebody that's seeking information, you need to keep in mind that a government agency is not required to answer your questions, and it is not required to provide information that does not exist in record form. And when I say you're not required to create records, and this just means an agency, it doesn't mean that an agency is not required to make copies of records or to convert them to a preferred format if possible. It just means that they don't need to manually create a brand new record that had never existed before. And of course, with most rules, with most hard and fast rules, there aren't any hard and fast rules. There are 3 exceptions built into the law about when an agency is required to create a record. There are only 3 exceptions. The Freedom of Information Law requires that every agency that maintains, that houses a public body, is required to maintain a record of how each member votes. Each member of that public body votes. You would think this would be contained in the Open Meetings Law, but it's not. For some reason, it's contained in the Freedom of Information Law. When a public body meets and they vote on something, the Open Meetings Law just says that the minutes must contain a record of the vote. So, for example, if you have a 5-member board and the vote passes 3-2, Open Meetings Law just says you need to say the motion passed 3-2. But here in the Freedom of Information Law, there's this provision that states you have to have a record that reflects how each member voted. So while there's no statutory obligation for that information to be contained in the minutes, from a common sense perspective, why would you have 2 records? Just include that if there's a split vote, if it didn't pass unanimously, the minutes likely, if not the minutes, some other record should contain a record of how each member voted. The second exception is that every agency is required to maintain and make available a list of the name, public office address, title, and salary of all public employees and officials. Public employees have a lesser expectation of privacy than the general public, so all public employees, their name, their title, where they physically work, and their salary is all public information. In addition, the last item that every agency is required to maintain is a reasonably detailed subject matter list. State agencies are required to have this information available on their website. I will note that a helpful, what's the word I'm searching for? So you don't have to reinvent the wheel for most government agencies. If any government agency is subject to the New York State Archives Record Retention and Disposition Schedule, an easy way to comply with this statutory requirement to maintain a reasonably detailed subject matter list is to adopt the Record Retention and Disposition Schedule established for your local government by the New York State Archives. Adopt that schedule as your reasonably detailed subject matter list. So, and if on the other side, if you're a member of the public and you're looking for a subject matter list for a level of local government, an easy way to find out what type of records every local government is required to maintain without even having to go to that government entity is to go to the New York State Archives and pull up a copy of the LGS-1, which is the Record Retention and Disposition Schedule for local governments. State agencies also have a Record Retention and Disposition Schedule, but I will note that most state agencies are probably going to have to beef up that standard because the schedule established by the archives is for all state agencies, and of course every state agency is a little bit different, and they're going to have records that are specific to that agency, so the schedule is probably not going to be sufficient to satisfy this requirement for a state agency. It can be a good base point, it can be a good jumping off point, but I would think for most state agency it's going to need to get beefed up a little bit. Earlier I talked about no obligation to create a record. So this is an issue that comes up. There's a difference between creation and preparing a copy. There's a provision of Freedom of Information Law that states an agency shall provide records on the medium requested by a person if the agency can reasonably make such copy or have such copy made by engaging in outside professional service. An example may be here, I mean, certainly if someone would like photocopies of a record, provide them with a photocopy. However, if on the other hand, if someone says, well, I like to have I like to do all this electronically, I don't really want paper, and I don't want to have to, right now, especially during COVID, I don't want to have to come into the office and pick up paper. Can you email them to me? If you, as an agency, either maintain the records in electronic form or can convert the records to electronic form as easily as you could photocopy, most common example here is scanning. If you can scan, if an agency can scan as easily as they can photocopy, in our opinion, they would be obligated to do so, and this is not creating a new record. It's just making a copy of an existing record. So the agency would have an obligation, if they have the ability to do so, to scan those records and email them to the requester, or scan the records and place them on an electronic storage device. So those are some examples of sort of that distinction between creation and preparing a copy. Another example that comes up quite frequently is the idea of data extraction. When agencies have databases, and there's a lot of data in that database, and the agencies probably have a certain number of reports that they produce from that database in the regular course of business. And I think the agency would understand that those reports that they produce in the regular course of business are certainly records that are subject to FOIL. But the question that comes up is the data itself subject to FOIL? And the answer is yes. It's information maintained in any physical form. So if an individual makes a Freedom of Information Law request for data that is maintained by an agency, and where the agency has the ability to run a report from that database, to query the database, and produce the elements, the data elements that are being requested, it is obligated to do so. It's also obligated to transfer the record to the medium requested by a person, to allow the transferred record to be read or printed. And that is clearly states that that shall not be deemed to be the preparation of the creation of a new record. The law clearly states that this querying a database, producing, running a report from the database, the law specifically states that's not creating a new record. A question that comes up with regard to this very, very frequently is agencies get a little bit antsy about providing records in native format, or let me use maybe a better term is editable formats or manipulatable formats. Agencies get a little antsy about that. They're concerned about providing a record to a requester that the requester then has the ability to edit or play around with, manipulate. However, you have to. The law states that if you have the ability to do so, for example, if someone wants files in Excel, which is editable, and you have the ability to do so, an agency is required to do that. Some agencies, like for example, would prefer to print it, convert it to a PDF and sort of lock it in. But if the person who's making the request wants it in Excel or Access or some other format of that nature, you have to provide it to them in that format. On the requester side, an agency is obligated to reasonably describe the record sought. And the question here is whether the agency can locate or retrieve the records with reasonable effort. And the answer to this question will likely depend on, well, first it's going to depend on the agency's record-keeping system. But often a significant factor is whether the records are in paper or electronic format. It's much easier to find electronic records, no matter what your record keeping is, than it is to find paper records if the records are maintained one way and the requester is looking for records that would require you to do search in a different way. I'm going to go back to this one. Actually, I don't want to stay on this for a little bit because it's a question that comes up fairly frequently. An example might be at the town government level. Municipalities contain information records relating to building permit applications. Those building permit applications are likely stored and filed. They're probably searchable by property address, perhaps property owner's name. However, they're probably not stored by project type. So, for example, if someone says, I would like make a Freedom of Information Law request of all building permit applications received by the town in the year 2019. The town can probably do that. It may take a little time depending on the size of the town. It may be a little bit labor intensive, but it's going to, that's how the records are going to be maintained. We're going to be able to locate those records most likely. On the other hand, if someone makes a Freedom of Information Law request for all building permit applications for people that wanted to install a pool, that may, if the records are purely in paper form, that just really they may not have the ability to locate those records with reasonable effort. And it's always been the opinion of the Committee on Open Government is that even if an agency knows that they likely possess the records somewhere, if they are not able to locate them with reasonable effort, it would be equivalent to finding the needle in the haystack. The agency is not required to do so. As I mentioned, with electronic records, finding things like this becomes a little bit easier, maybe queries or something along that nature. But paper records, that makes it a little bit more difficult. Every agency is required to designate a record, at least one or more records access officers. And the records access officer for every agency is the individual who has the responsibility of coordinating the agency's response to the Freedom of Information Law. Every agency is supposed to designate that person by name or by specific job title, by their business address, and when a requests are accepted by email, which at this point all agencies should be able to accept via email. An email address should also be provided for submitting Freedom of Information Law requests. And as I said, the records access officer is the person who has the duty of coordinating the agency's response to public requests for access to records. That doesn't mean that the records access officer is the only person within an agency that has legal responsibilities relating to FOIL. Everybody who works for a government agency has some level of legal responsibility in this regard, but the records access officer should be your point person, so to speak. Time limits. So, when an individual submits a Freedom of Information Law request to an agency, there are certain time limits that apply for responding to that request. The first marker is the 5 business day marker. Within the first 5 business days of receiving a Freedom of Information Law request, an agency has an obligation to do something. That may be provide the records sought, deny access to the records sought, state you don't have the records that you're seeking, or a fourth common response, particularly for larger agencies and for larger requests, is within that first 5 business days, the agency is obligated to acknowledge receipt of the request and give a date by which they plan to respond. What the law states is establishes sort of a rule of thumb for most requests, because it states that if you require more than 20 business days, there are certain steps that need to be taken. So sort of that ground level is that when you acknowledge the request, you can indicate we plan to respond within the next 20 business days. And that's going to be acceptable. For example, if we're looking at it from a challenge at the court, an acknowledgement of a request and a statement that we will get back to you within 20 business days, it's always going to be acceptable at the court level. If, however, an agency requires more than 20 business days, they have an obligation to provide a date certain by which they plan to respond that is reasonable under the circumstances. They can do this at 2 different points. They can either do it right upon receipt at the acknowledgement stage. So, for example, when they send out the 5 business day acknowledgement letter, based on the volume and complexity of the request, they may state, provide a date certain that is 3 months from now. And they're also obligated to provide a reason for the delay. So in that acknowledgement letter, they would state, based on the volume and complexity of your request, we will respond within 90 calendar days. The other option, if an agency is not quite certain how long it's going to take to respond and they need more time to dig in and gather the records before giving a date certain, that 5 business day letter can indicate that we plan to respond to you within the 20 business days. And if as that 20 business day approaches and before it expires, the agency realizes it needs more time, it gets one more bite at the apple. It's permitted to, at that point, provide a date certain that's reasonable under the circumstances. Here's where it gets a little bit complicated because there's a bit of a distinction between what we at the Committee on Open Government have believed for a long time based on our understanding of the statute and what the courts have held. Committee on Open Government forever has always stated that the law does not allow for repeated extensions. The law and our corresponding regulations state that if you need more than 20 business days, you're supposed to give a date certain that's reasonable under the circumstances. And just from our very understanding of that term, a date certain, that's what it means. It doesn't mean you keep bumping it out. However, the courts have really permitted agencies to engage in repeated extensions. They haven't indicated that's not permitted under the statute. The courts have allowed this. Generally, they're going to be looking at the reasonableness factor. Courts will look at the reasonableness factor. Are the delays reasonable? Is the agency keeping the applicant aware of the need for additional time? From our perspective, our concern at the Committee on Open Government is with these repeated extensions, the person making the request has no idea when the end is in sight. They have, for example, if an agency right off the bat states, this is a very, very large request and we're not going to be able to get back to you for 6 months, at that point, the request, they want to reevaluate their request and narrow its scope. But if they're not told that, if they just keep getting bumped out month after month after month, they don't really know when the agency is going to respond. And they don't know, it makes it difficult for them to figure out how to proceed. The time frame for appeals is an applicant has 30 days to appeal an affirmative denial of access, and the agency has 10 business days to respond to that appeal. I think I popped on the screen briefly. I apologize, I'm not probably going to be able to respond to chats as they come up because I'm terrible at paying attention to both things. But in terms of what is reasonable, there is a provision in our regulations that lists examples of the types of things that can be taken into account when determining what is reasonable. It's the volume of the request, the number of FOIL requests received by an agency. It's all very practical elements, but if you want to look, it's let's see if I can do this for you. It's a good question. So these little learning here. So here I'm going to pull up our regulations. And here, this paragraph right here, it says, in determining a reasonable time for granting or denying a request under the circumstances of a request, agency personnel shall consider the volume of a request, the ease or difficulty in locating, retrieving, or generating records, the complexity of the request, the need to review records to determine the extent to which they must be redacted or must be disclosed, the number of requests received by the agency, and similar factors that bear on an agency's ability to grant access to records promptly and within a reasonable time. So that is how our regulations establish guidelines for determining reasonableness. Wrong one, sorry guys. Really should have somebody with more technical expertise doing this for you. Oh shoot, let's see, nice stuff. A while back, probably not too long ago, but if the FOIL was amended to require that if an agency is able, it must accept requests by email. And in my opinion, every agency should be able to accept requests by email at this point. There's just really no reason not to be able to accept FOIL requests by email, in my opinion. Agencies cannot require a requester to use its own form, but it can require that requests be made in writing. There's nothing wrong with an agency creating a form and having a form available for the applicant to use. People like forms, makes their lives easier. They don't have to reinvent the wheel, no big deal. However, if an agency receives a request in writing that's not on its form, the request cannot be rejected based on the fact that the applicant didn't use the agency's form. And in addition, the applicant shouldn't be made to jump through additional hoops by, let's say, you submit a request in writing for certain records, the applicant gets a note back from the records access officer saying, well, first you have to fill out this form. No, the applicant should not be required to fill out that form prior to the request being processed. There are two types of situations that give rise to the right to file an administrative appeal under the Freedom of Information Law. And the first is the more straightforward, simple, the express or affirmative denial of access. And that's when an agency acknowledges that it possesses the record that the person is seeking, or that it is being withheld in whole or in part. That the agency is asserting one of the statutory grounds for denial with regard to that particular record. If that occurs, the agency is obligated to notify the person in writing of the reason for denial, and they're obligated to provide directions about how to file an appeal, to whom that appeal should be directed. The second scenario that gives rise to the right to file an administrative appeal is what we refer to as a constructive denial of access, and that's when the agency fails to respond to a request within the time limit set forth in the statute. So if an applicant submits a request for records and 5 business days comes and goes, the applicant then has a right to file an administrative appeal. If the agency acknowledges the request and states we'll get back to you within 20 business days, the agency fails to do so, can be treated as a constructive denial of access and file an appeal. Another scenario is under our regulations, an applicant has the right to appeal if the agency provides a date certain by which they plan to respond, and the applicant does not believe that that date is reasonable given the circumstances. So say, for example, someone makes a very, very simple, straightforward FOIL request, and the agency says, we'll get back to you in 6 months. That just may not be reasonable. In most circumstances, it's not going to be reasonable. So under those circumstances, an applicant has a right to file an appeal of what they consider to be a constructive denial of access. Model language for these types of appeals can be found on our website. I hesitate to go back because I keep messing things up, but if anyone, if you look at our website, there's a heading called Publications. One of our publications is called Your Right to Know, and that's a really good overview of both the Freedom of Information Law and the Open Meetings Law. It contains a lot of the information that we're talking about today. And so that's a good little resource. You can print it out in booklet form if you want, keep it on your desk, mark it up. But yeah, on the online version of that publication, we have a series of templates of sample language, and one of them is an appeal when an agency, administrative appeal when an agency fails to respond in a timely manner. So if you need to file an appeal of that nature, we do have sample language for you to file from. All right, so here are some first series of permissible statutory grounds for denial. So I think what I'll do is, so here's the first 6. Here's another 3. I did not list the rest of them that are contained in the statute because they all relate to vehicle and traffic law and so rarely come up that I don't want to waste anyone's time going over them in too much detail. But if you ever have records that are governed by vehicle and traffic law, you're going to want to focus on those additional grounds, permissible grounds for denial in the statute. So I'm going to go over some of the grounds for denial, not all. I'm going to go over some of the more commonly asserted grounds for denial in a little bit more detail. So the first are records that where the language is they are specifically exempted from disclosure by state or federal statute. Some common examples of this situation are attorney-client communications. So, for example, you have a municipality and you have municipal employees or elected officials, and they have emailed their municipal attorney requesting legal advice. And the municipal attorney responds to that request in writing, providing legal advice. That type of exchange would be covered by the attorney-client privilege pursuant to civil practice law and rules and can be exempt by statute. That is a ground for denial that an agency can assert if the communication, if the record involves advice from the municipal attorney, from the agency attorney. Another common example for school districts or for SUNY or CUNYs are student records, student education records. Access to those records is governed by federal statute. And so if I made a freedom of information law for my neighbor's child's education record, clearly I'm not going to get them. They are governed by a separate statute and they are confidential. They are exempt from the freedom of disclosure under the freedom of information law by that federal statute. Mental health records, maintained, for example, at the county level, mental health records are mental health records maintained by facilities operated by the Office of Mental Health or the OPWDD. Those types of records are exempt by state statute and by federal statute, given the fact that they're likely confidential pursuant to federal privacy regulations, HIPAA. Another example are autopsy records. There's a provision of New York State county law that makes autopsy records maintained by county medical examiners, coroners. Those records are confidential by statute. County-operated E911 records are confidential pursuant to New York State county law. And there's a provision of the Personal Privacy Protection Law that makes all Social Security numbers confidential pursuant to statute. So those are just some examples. It's certainly not all-inclusive. But if access to the records is governed by one of these statutes, that's the statute that matters. Agencies are going to want to make sure that they're complying with that specific statute before even thinking about looking to FOIL. The second example, a second ground for denial that comes up pretty frequently is when an applicant record or a portion of record can be withheld when disclosure would constitute an unwarranted invasion of personal privacy. This personal privacy is subjective, and what one person may consider an unwarranted invasion of personal privacy, another person might find perfectly fine. Sometimes it's very subjective, so it likely is going to come down to what a reasonable person would consider objectionable. Examples of situations where we have offered the opinion, and often these opinions have been upheld at the court level, are employment applications of persons not hired. So say there's a job listing at a government level and 10 people submit their applications, one person is hired. Well, the employment history of the person who's been hired and is now a public employee to a large extent should be available, but the information relating to the people that were not chosen can be withheld. This next bullet point's a little bit interesting right now because there's a lot going on in relation to the repeal of Civil Rights Law Section 50A and disciplinary records of police officers. We've held for a long time, or excuse me, I shouldn't have held is not the right word in our office. We've offered the opinion for a long time that in general, unsubstantiated allegations of misconduct against public employees can be withheld on personal privacy grounds. I don't, that's not a black and white answer. It's going to be factually dependent. It's going to depend on the nature of the records. But that's an opinion that we've offered for a long time. Certainly medical information contained by an agency, whether it's about their own employees or whether it's about other people, even if it's not covered by HIPAA or by state law, if disclosure, in our opinion, any information relating to a person's medical history, medical conditions can be withheld. There's a provision specifically stating that public employees' home addresses can be withheld as an unwarranted invasion of personal privacy. Lists of names and addresses of natural persons, if that contact information would be used for solicitation or fundraising purposes, can be withheld as an unwarranted invasion of personal privacy. An example there would be all town governments probably maintain a listing, a record of all names and addresses of individuals who have who purchased a dog license. And a new business opens up and they're doing mobile dog grooming. And they go to the town clerk to make a FOIL request for the list of names and addresses of all individuals to whom dog licenses have been issued in the past 5 years. If the town chooses, they may withhold the records on the ground that the information will be used for solicitation and fundraising purposes, and as such would constitute an unwarranted invasion of personal privacy. Another option in that situation is if you don't know why the person is asking for that information, the agency can request a certification that the requester will not use the information for solicitation or fundraising purposes. And if the requester refuses to provide that certification, the request can be denied on that ground. A fairly recent amendment to FOIL is that mugshots, booking photographs, have been included as a record which, if disclosed, constitute an unwarranted invasion of personal privacy. And my forward button is not moving, so of course it didn't work too much that time. Okay. Another example at local government levels are law enforcement records. If a request for example, an incident report comes in, depending on the timing of the case, depending on what's going on with the investigation that relates to that incident report, the agency may choose to deny access. If they're going to deny access, it has to meet both aspects of a two-part test. The first aspect is that the record was compiled for law enforcement purposes. And the phrase compiled for law enforcement purposes doesn't necessarily mean that they were originally compiled for law enforcement purposes. It could be that at the time that the request has been made, that the records being requested have been compiled and put together for law enforcement purposes. And that was a fairly recent Supreme Court decision from 2017 involving a New York Times FOIL request to the executive chamber relating to investigation. This exemption also does not apply just to records compiled for criminal law enforcement. The court has held that if the records are being compiled or compiled for civil law enforcement, like many different state agencies have civil law enforcement authority with regard to their specific subject matter, a specific court decision involving the New York State Education Department. Even if it's for civil law enforcement purposes, this exemption might apply. So that's the first part. The record has to have been compiled for law enforcement purposes, but that's not enough. You have to meet the second part of the test as well. The agency has to determined that some harm would be caused by disclosure. And the 4 examples of harm, or for the types of harm that the law envisions, is one, that disclosure would interfere with a law enforcement investigation or judicial proceeding. The second is that it would disclosure would deprive a person of a right to a fair trial or impartial adjudication. The third is that it would identify a confidential source or disclose confidential information relating to a criminal investigation. And the last type of harm envisioned by the statute is that disclosure would reveal non-routine criminal investigative techniques or procedures. So here we're not talking about necessarily standard operating procedures that are fairly straightforward and most people have a basic understanding of. Here we're talking about the type of investigative techniques or procedures which, if made available to the public, would allow the public to perhaps evade detection, or you don't want to give the burglar the combination to the safe, essentially. And so that's the example there. Another ground for denial that agencies may need to assert, or may choose to assert, I should say, and I'll back up here just for a moment because I didn't say this at the beginning, is that aside from records that are confidential pursuant to state or federal statute, in those instances, the other state or federal statute is going to govern access. But with regard to the remainder of the grounds for denial that are identified in the Freedom of Information Law, all these grounds for denial are permissive. They allow an agency to deny access on these grounds, but do not require an agency to deny. So, for example, using what I have up on the screen right now, the intra-agency and interagency material, here we're talking about records that reflect an agency's deliberative process. Internal emails, internal memos, draft documents to some extent. Those records, if an agency chooses and if they appropriately fit within the ground for denial, it can be withheld, but you're not required to. If an agency wants to disclose those records, they're free to do so. So with this intra-agency and interagency material, so intra-agency is all within the same agency. Here at the Department of State, at a larger level, communications between and among Department of State employees would be considered intra-agency. If, however, I email a colleague over at the Department of Health, that's 2 different people from 2 different agencies communicating with each other, and that's interagency material. So the law allows intra-agency and interagency material to be withheld, except there are exceptions to the exception. An agency is required to disclose if these elements are part of interagency material. The agency is required to disclose these parts. And the first one is statistical or factual tabulations or data. So objective, statistical, factual information that is contained within interagency material is required to be disclosed. Instructions to staff that affect the public, required to be disclosed. A fairly simple example of this is, over a year ago when a lot of changes were occurring in terms of workplace situations, many, at every level of government, but here, for example, at the Department of State, which is our administrative home, we received guidance advising us not to appear in person, basically telling us, here are the rules regarding essential employees. Here's the rules regarding non-essential employees. Here's what you should do if you have the ability to all of that type of thing that were instructions to staff that affect the public, because the public needed to know how these government agencies were going to be continue to be able to assist them. So emails from the administration of a state agency to all state employees directing them about what steps to take, particularly in the beginning of the COVID emergency, in my opinion, would reflect instructions to staff that affect the public. A final agency policy or determination is information. So, for example, if there's been a complaint made to Human Resources, and Human Resources issues maybe it's a disciplinary complaint, and the Human Resources investigates and issues a finding of misconduct, and that finding also reflects the penalty that's being imposed against the employee. That's a final agency policy or determination. And the final example of interagency material is external audits, and specifically external audits conducted by the Office of the State Comptroller is identified in the statute. So if OSC comes in and audits a municipality, that cannot be considered interagency material. So that is not all-encompassing. That is not all of the grounds for denial, but it's some of the most common. So I mentioned way back at the beginning is that when there's a denial of access, every agency is required to put that denial in writing, and the denial should include the reason for the denial and direct the person how to file an administrative appeal. And then the agency applicant then has 30 calendar days to file an administrative appeal. If they miss the 30 calendar days, if they choose not to appeal within the 30 calendar days, they'll be deemed to have exhausted their administrative remedies. The FOIL appeals officer by law is the head or governing body of the agency, or the person or persons designated by the head or governing body. The FOIL appeals officer cannot be the same as the records access officer. That's by regulation. Within 10 business days, the FOIL appeals officer must either provide the records sought or fully explain the reason for further denial, or a combination of both. The law does not contemplate a remand back to the records access officer. The records access, if the FOIL appeals officer is reviewing the same record that the records access officer reviewed, it is the responsibility of the appeals officer to make a determination with regard to rights of access. Fees. If I get nothing, if people get nothing, particularly agencies, I should say, if you're an agency employee, if you get nothing else out of this presentation, I'm hoping that people will remember what I tell them about not combining fee structures. Under the Freedom of Information Law, there are two fee structures, and they cannot be combined. It's either one or it's the other. It is not both. If an individual makes a FOIL request and they would like copies of those records in photocopy, the agency is permitted to charge 25 cents per photocopy, a copy that's 9 by 14 inches. That is it. That is all the agency is allowed to charge, nothing else. Cannot charge for the time. An agency cannot charge for administrative time. It cannot charge for search time. It cannot charge for the time it takes to review the records to determine rights of access. It can only charge 25 cents per photocopy. Okay, second fee structure. If the agency is providing the copies in some format other than photocopies up to 9 by 14 inches, that's when the second fee structure comes into play. If it's some other format, the agency can charge the actual cost of reproduction. When determining the actual cost of reproduction, the law identifies factors that the agency is permitted to consider. And one is what I shorthand refer to as the 2-hour rule. If it takes at least 2 hours for an agency employee to prepare a copy of the record, and here it is, prepare a copy of the record, not prepare the record, prepare a copy of the record, the agency is permitted to charge the hourly salary of the lowest paid employee capable of performing the task, but again, only if it takes at least 2 hours. So let's use scanning as an example. Someone wants the record scanned instead of photocopied. If it takes half an hour for an agency employee to scan the records, the agency is not going to be permitted to charge a fee. If it takes 2 or 3 hours for the agency employee to scan records, it will be able to charge a fee. Anything 2 hours or more, the agency can charge the hourly salary of the employee capable of performing the task. Please, please, please keep in mind that this 2-hour rule only relates to the time it takes to prepare a copy of the record. You cannot take into consideration the time it takes to search for the record. You cannot take into account the time it takes to review the records to determine rights of access. So for example, if you need to send these out to your attorney to review and prepare and redact those records, that is not a cost that can be passed along to the requester. You're only allowed to charge the cost of making a copy of the record. So as I said, if I get nothing else through to particularly agencies, employees on this, I'm hoping that gets through, because I feel like that causes a lot of confusion for people. Agencies very often, I feel like, are trying to charge for employee time for things that they are not permitted to charge for. Very frequently, it's the review time or the search time, not permitted to charge for that time, just the time it takes to make the copy. Agencies are allowed to pass along the cost of an electronic storage device, the actual cost of an electronic storage device. And if an agency needs to send a record out to a third-party vendor, sometimes this comes up with large records like blueprints and maps and things like that, or maybe it's audio or video that you don't have the ability to do in-house. If you don't have the technology to do it in-house and you need to send it out to a third-party vendor, then you can, whatever the vendor charges you, you can charge the requester. Certainly for large fees, and particularly when that second fee structure, in my opinion, anytime there's any sort of significant fee, let the person who's making the request know what the fee is going to be before preparing the copies. Certainly if you need to send it out to a third-party vendor, don't assume that the requester is willing to pay the fee, because you don't want to be, as an agency, you don't want to end up eating the cost, making the copy, eating the cost, and finding out, that's more than I can afford. It's not, I didn't really think that the fee was going to be, I didn't think there's going to be any fee at all. Whatever the case may be, I certainly encourage, with the second fee structure, with the non-photocopy, there's actually an obligation to notify them of the fee in advance. But even for photocopies, particularly if it's a large amount, let the person know in advance before you make the copies. That way they can make an informed decision. The last thing before I try to get to some questions is enforcement. So if an applicant is denied access to records after filing an administrative appeal, or if the agency fails to respond to the administrative appeal within 10 business days, the applicant has a right to initiate a civil practice law and rules Article 78 proceeding against the agency. If the applicant substantially prevails, the court must, in some circumstances, and may, in other circumstances, award attorney fees and other reasonable litigation costs. It is mandatory on the part of a judge when a requester has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. It is discretionary on the part of a judge when the requester has substantially prevailed and the agency failed to respond to a request or appeal within the statutory time. Let's see. You know what, this other section really has more to do with like CLE programs, and I think I've talked about a lot of them. So what I'm going to do now is I'm going to stop sharing my desktop. I'm going to go over here, and I'm going to try to go through, if people have submitted any questions through chat. If you submitted a question through chat and I don't address it for you, please feel free to contact me directly. It's possible I'm not addressing it because I think it's so factually specific that we have a really, let's see how many people, see how many participants I have logged on. I had actually over 350 people sign up, but of course I know that number's always going to go down, but I have 267 people logged on right now, so I do want to make sure that if I'm addressing questions, they're of general interest. So I'm just going to slide through here. One person asked the question about reasonableness in terms of time frames. It has to do with the number of FOIL requests currently being processed by an agency, and how does that affect reasonableness in terms of how long an agency, so the agency receives a FOIL request and it's the 1,000 FOIL requests they've received that month, and the agency comes back and says, we'll get back to you in 6 months. Does the fact that that is the 1,000th FOIL request received that month impact reasonableness? 100% certainly it does. If one agency may be able to respond to a FOIL request for a particular type of record within days, that it takes another agency months to respond to, solely due to the sheer volume of requests that other agency receives. Certainly in an ideal world, we would like to see larger agencies, and particularly agencies that are dealing with a higher volume of FOIL requests, receive, this is my personal opinion, I don't want to speak for the committee as a whole, but I think I would like to see increased staff at those levels to take the burden off the people that are dealing with the Freedom of Information Law, so it doesn't get to be such a huge backlog. In an ideal situation, there would be appropriate staffing so that it doesn't take that long for an agency to respond to small requests. But I understand right now in a practical situation, it's not always going to be possible to have the staff available to process things as quickly as an applicant might like. Let's see. Someone asked a question about after the repeal of Civil Rights Law Section 50A, which, if any of you are not aware, up until June of last year, governed access to the personnel records of police officers, corrections officers, and paid firefighters. Up until June of last year, those records were confidential pursuant to Civil Rights Law Section 50A. That law was repealed in June of 2020. And now access to those records is governed by the Freedom of Information Law in the same way as any other public employees' personnel records are. And the question sort of has to do with pending investigations. So if there's, for example, a complaint, an allegation of misconduct against a law enforcement officer, and that investigation is still being investigated, and there's been no finding yet, in our opinion, there's a likelihood that those records should be able to be withheld as an unwarranted invasion of personal privacy. This is a developing area of case law. It's going to be interesting to see what happens in the next year or two. But at this point, in my opinion, in most circumstances, it's going to be reasonable to withhold pending investigation records reflecting pending investigations into allegations of misconduct until there's been a finding. Someone asked about the slideshows, and as I already pointed out to everybody, those slideshows the slides are available on the website. Yes, they're from February 2020, but the same ones you're looking at today. I use the same one over and over again. If I update them at some point, the updated ones will become available onto the website. Someone's asking about communications between the clerk, deputy clerk to the legislature. Are they protected by attorney-client privilege if they're seeking legal counsel and advice from legislative counsel? If we're talking about county again, keeping in mind that the state legislature is not an agency, so any communications between, for example, a state agency and the New York State Legislature, or the New York State Legislature and a local municipal agency, are not going to be considered interagency. because the New York State legislature is not an agency. If, on the other hand, we're talking about county legislatures, yes, they're intra-agency, and anytime a municipal employee is requesting legal advice and receiving legal advice from their municipal attorney, the likelihood is that's going to be covered by the attorney-client privilege. If a FOIL officer responds in a timely fashion, but the recipients to whom the FOIL officer has, I think this question it's sort of a practical question about what to do, what the struggles sometimes that a records access officer has when dealing with their coworkers and other employees within the agency that perhaps don't fully understand their obligations under the Freedom of Information Law. It's really not a legal issue, it's a practical issue. All I can advise is that the records access officer, and hopefully they have support from other areas, need to remind all employees, all department heads, whatever the case may be, they need to be reminded of that FOIL is a statutory obligation, and that there could be, by not assisting the records access officer, by not providing the records to the records access officer when requested, they're exposing the municipality or the agency to legal liability. So again, it's really just a practical issue of trying to hammer that issue home with employees, government employees who perhaps are not fully understanding their obligations. Someone asked about witness contact information, particularly if a witness does not wish to remain confidential. Ultimately, while an agency can take into account, there's nothing necessarily wrong with taking the witness's wishes into account, but it shouldn't be the deciding factor. Ultimately, the agency is going to have to decide whether they wish to disclose or withhold names and contacts of witnesses to a criminal incident or any type of incident on the basis that disclosure would interfere with, or excuse me, that's not what I meant to say. If in that case, if the person doesn't wish to remain confidential, then they're not really a confidential source, but it still might be able to be withheld as an unwarranted invasion of personal privacy. And ultimately, that's up to the agency to determine. Someone again asked about the PowerPoint, which is available online. There's someone asked about photocopies fees. Is there any obligation to waive the cost for the first few copies? Nope. If it's one photocopy, you can ask for your quarter. Does a request need to contain a reason for requesting the specific information? No. There's no obligation. An applicant for records does not need to provide a reason for the request. The identity of the applicant for records and the reason why they want the records in most instances is going to be irrelevant. The exceptions generally have to do with privacy. So for example, as I talked about earlier, agencies are permitted to request the certification that their information will not be used for solicitation or fundraising purposes. That's really the one exception I can think of where you can require that they identify their purpose. In terms of even identity of an applicant, if we're talking about a public record or a record that would be public to anyone, I could create an anonymous Gmail account. I could go in, create a Gmail account that says, 1234foil@gmail.com and submit a Freedom of Information Law request. I live in the town of Bethlehem, so say I submit a Freedom of Information Law request to the town of Bethlehem for copies of meeting minutes for all meetings that occurred in the month of March. the records access officer for the town of Bethlehem should just respond to my email and provide them to me. They shouldn't ask me who I am. They don't need my identity in order to provide access to records that are publicly available to everyone. Now, certainly if for some reason the records that are being requested do involve privacy issues, and where you would only, the agency is only going to disclose the records to the person who's the subject of the records, certainly that's an exception there where you can request proof of identity. Let's see. This is talking about the remand process, and this is a very complicated issue, particularly when you're, let me back up a little if people don't know what I'm reading here. And the question had to do, earlier I mentioned that when a FOIL appeals officer receives a FOIL appeal, they have 10 business days to respond, and they're not supposed to remand it back to the records access officer. There's nothing in the law that allows them to do this. The law specifically states, in response to a FOIL appeal, the agency, apparently my battery's running low, so give me a second. I just want to make sure I plug in my computer before I lose y'all. Sorry about that. I was hooked up to my docking station earlier, which is why I was not plugged in, but hooked up to the docking station it was messing with the screen sharing, so I unplugged the docking station but didn't plug in my laptop. So here we are. We'll go back to the question. Okay, so the law states that in response to a FOIL appeal officer, or FOIL appeal, the FOIL appeal officer is either supposed to uphold the denial or provide access to the record sought. Those are the only two options in the statute. So from a pure statutory position, there's nothing in the law that allows a FOIL appeals officer to remand. However, I understand that there are practical considerations. Let's say, for example, an individual makes a FOIL request for a large volume of records. And for whatever reason, the records access officer misses their time frame for either acknowledging, or they acknowledge but miss their time frame for responding. So the person who makes the request files an administrative appeal based on a constructive denial. Here the problem is that no initial determination, the records access officer may not have even had an opportunity to pull all the records yet. Records access officer may not even have all of the records available for review yet in order to make a determination. Or perhaps they have the records available, but there's such a volume of records that the original records access officer hasn't had a chance to go through them all to determine rights of access. I don't have great guidance for you. I think the agency in that circumstance has to do what they believe is the best thing to do for the requester and for the agency under the law. I think there may be some circumstances where someone files an administrative appeal, says, I submitted my FOIL request on March 1st. The agency acknowledged my request on March 8th. However, you said you would get back to me by April 8th. It is now April 15th. I haven't received a response. I treat it as a constructive denial and appeal on that basis. FOIL appeals officer gets it, reaches out to the records access officer and says, yeah, that FOIL request is sitting on my desk and it's 5 file boxes worth of records that I haven't had a chance to get through. I apologize, I missed the deadline. Honestly, there's no practical way for the FOIL appeals officer to get through those 5 file boxes worth of records in 10 business days. It's just not possible. In that circumstance, I can't tell you that the law allows it, because it doesn't. Do I think it may be reasonable in that circumstance for the FOIL appeals officer to say, yes, we acknowledge that we missed our deadline. To that extent, I uphold your appeal. However, given the sheer volume of your request, we are going to require this much time, and here's the date certain by which we plan to respond. As I said, do I think that the statute permits this? Nope. Do I think it's reasonable? Yes. So that's a difficult situation. One question has to do with FOIL requests that are, someone submits a Freedom of Information Law request for all, let's say, all email communications sent or received between several government agency employees. The agency does a search for responsive records, and it turns out there are a minimum of 10,000 emails that need to be reviewed to determine rights of access. The question is, does the agency need to go through the process of reviewing those records to determine rights of access, or can the request be denied for undue burden on the agency? So Freedom of Information Law specifically states that a request cannot be denied on the grounds that it is too burdensome. However, sometimes the question is, has the person reasonably described the record sought? Has the applicant reasonably described the record sought to allow the agency to identify the specific records that the person is seeking? In addition, there is an old case, there's not a lot of case law on the subject, but there's an old case law predating email that had to do with a request for the entire content of filing cabinets. Basically, someone says, oh, I see all those filing cabinets behind the town clerk. I want everything in there. And the court had, no, we think a request of that nature goes beyond the scope of what FOIL intended. So in our opinion, there may be a reasonable argument that a request for records that returns 10,000 plus pages of emails, which then would need to be reviewed to determine rights of access, may very well go beyond the scope of what FOIL intended. To a large extent, in my opinion, it's also going to depend on whether the agency reasonably believes that the content of those emails can be withheld. I've had a situation come up recently that distinguishes between a request for all emails that are all internal to an agency and requests for emails that are between an agency employee and a private third party. If it's a private third party, particularly a business, not a natural person that might have privacy interests, but a business. So you've got an agency employee and somebody who works for a third party company. You've got a large number of emails between those two individuals. Well, you have to think about it. What ground for denial can be asserted? I'm not sure that there can be any ground for denial asserted. It may very well be that those emails just need to be turned over in their entirety. On the other hand, if they're all internal, intra-agency material exception, the amount of work that would go in reviewing, I don't know that the juice is going to be worth the squeeze, so to speak. The agency could spend a year reviewing those emails, and the person might get 5 pages worth of records because the rest of it's going to be subject to exemptions. It's going to be a very factually specific case. I've already talked about the website, the slides quite a few times, so I'm going to skip over that. A school board asks a person who had filed a complaint regarding the behavior of another person. Based on their bylaws, and the person complaining asks, I'm not sure that I understand the question. If there are, in my opinion, records reflecting names of complainants can be withheld in most circumstances as an unwarranted invasion of personal privacy. The names of the individual against whom the complaint has been made, it's going to depend on the status of the complaint, whether there's been whether there's been an investigation, whether there's been a finding. and whether there's been an actual finding of misconduct or whether the complaint ended up not being substantiated. Someone makes a complaint against me and the state conducts an investigation and says, yep, Kristen, you messed up. So we're going to substantiate the complaint and here's your penalty. That information is going to be public. If they investigate and say, no, we looked into the facts surrounding the complaint, we don't think you engaged in the misconduct that they're alleging, so we're dismissing the complaint. If that's the case, those records of that complaint can likely be withheld as an unwarranted invasion of personal privacy. Someone says, can you charge for the time employees spend to scan hard copies in order to convert them to PDF to respond electronically? If it takes, yes, if it takes at least 2 hours. Can the appeals officer ask for more than 10 business days to respond? They can ask. They do not, the requester does not need to grant an extension beyond 10 business days. Once that 10 business days comes and goes from a legal perspective, if the applicant then does not have records in hand, if they have not prevailed after an administrative appeal after that 10 business days, at that point the applicant has a right to bring an Article 78 proceeding in state Supreme Court. I'm sorry. I'm going to just try to take a couple more questions and try to finish up around 11:30 because I know everybody's got busy lives. Let's see, I've recently become a FOIL officer for my division. I have a QA account access request. Oh, you know what, I'm not that familiar with the QA, so I'm sorry, that's not something that I can help you with. An elected official, in this case a council person, opts to receive a stipend to use their own Wi-Fi and device for city business. Are communications exchanged on this device foilable, whether using their official email address or their private email address? What is the process for obtaining exchanges made using private email address? To a large extent, whether the person receives a stipend or not is not really going to be relevant. What's relevant is whether the communication is sent or received by the public employee or official in their official capacity. And that is regardless of whether they're using their official email address or their private email. Well, okay, let me clarify. If they're using their private email address, the question is, you know, I've got a Gmail account. If I start, instead of using my Department of State email address, I decide to start using my Gmail account to email back and forth with my boss. Well, those are records subject to FOIL because I'm not emailing her. I mean, you know, we're friends outside of work, but I'm not emailing her likely because we're friends. Maybe I'm emailing her because I'm trying to avoid using my Department of State email account. But if she and I are discussing Committee on Open Government Business, those are emails subject to FOIL. If someone is using their official government-issued email account, any email sent or received on that account are going to be subject to FOIL, regardless of content. They may not need to be disclosed. You're going to look to see whether any of the exemptions apply, but any communication sent or received using a government-issued email account is going to be a record subject to FOIL. If it's sent or received using private email, you're going to look to content. Someone asked about hospital police disciplinary records. I'm not sure if that means like security guards, but unless they're an actual law enforcement police officer as defined by penal law. Well, first of all, Civil Rights Law Section 58 has been suspended, so access to all disciplinary records is governed by the Freedom of Information Law. Now, there's no special protection for them. To a large extent, there are specific provisions of FOIL that relate to police disciplinary records, but there's no blanket protection anymore. During COVID, many employees work remotely using personal computers. Is this entitled agency? We represent unlimited access to all the information on our personal devices? No. Well, that's not really a FOIL issue, but I'm just going to say it anyway. No. If someone had a second part to their question earlier about personal devices and private email, the best an agency can do is ask. I mean, if you on a personal device, I think there's an important distinction between devices and email accounts. Honestly, I'm sitting here on my state-issued laptop, but sometimes I'm using my personal smartphone. I've got another work phone, but it doesn't matter. Sometimes, on occasion, I've opened up the access to my Outlook account from my personal laptop at home. That's completely irrelevant. It doesn't matter what I'm using to access those accounts. What matters is the account itself and why I'm sending those communications. If you are working on your private computer, but you are using your state government email account, any communications sent or received using that government-issued email account are going to be subject to FOIL. That doesn't mean that your pictures of your kids that are also stored on your personal device are subject to FOIL. It's just the communications that are, think about it from the definition of what a record is. It's records maintained by, with, or for an agency. And your pictures of your kids are not records maintained by, with, or for an agency. The emails you send as a government employee are. So that's the distinction. But no, having, using your personal device does not expose your personal, all records maintained on your personal device. When an agency needs records that are responsive to a FOIL request, if those records include emails, the likelihood is they probably don't even, need to ask you. They probably have behind-the-scenes mechanisms for just searching employee emails, because every time a government employee logs onto their computer, they're consenting to have that information be made available to other people. Any information, any correspondence sent or received, at least on the state, that's what I can speak to most clearly, is that state agency emails, anything I do on my computer, on my state computer, any emails that I send or receive using my state-issued email account, I have no expectation of privacy. So anyway, we're at 11:34. We've gone a little over what I intended, but I really, really appreciate everyone who has logged on today. If I was not able to get to your question, please feel free to email me. I'm happy to respond. And I hope everyone has a wonderful day. Thank you very much. Have a good one.